Welcome to the Computational Antitrust Podcast. My name is Thibaut Schrepel. I'm a faculty affiliate at Stanford University Codex Center and the creator of the Computational Antitrust Project, which explores how legal informatics can benefit antitrust law. The project brings together over 65 competition agencies and 35 academics in the advisory board. Each month or so, we publish an academic article on the subject of computational antitrust. You may find these publications at computationalantitrust.com. Today, I am thrilled to be receiving Catalina Goanta and Jerry Spanakis, who co-authored a paper for us entitled Discussing the Legitimacy of Digital Market Surveillance. Catalina is an associate professor in private law and technology at Utrecht University, and Jerry is an assistant professor in machine learning and data mining at Maastricht University. Full disclosure, I've known both of them for years. We share a lot in common, and I'm sure this will appear in the conversation, including musical taste, but closer to our subject, we also share a common approach when it comes to law and computer science, if only for one thing, which is that none of us hates or dislike technology. So that's already a lot we have in common. And so without further ado, welcome to both of you. Could you to start with, summarize the main contribution of your paper in just 1 or 2 minutes?
Hi, Thibaut, first of all, and thank you so much for your kind invitation. It's a pleasure for Jerry and I to be here. Jerry, I'm sure, is going to build on this later as well. But first of all, we just want to say that it's a fantastic opportunity to have a conversation with you as being the originator of the most innovative project in antitrust globally right now, your project on computational antitrust. Going to our paper, so this in kind of multidisciplinary view that we have, I think, on the question of market surveillance is based on work that Jerry and I have been doing together in various fields that mostly touch upon natural language processing and consumer protection. And the paper that we wrote together is kind of a reflection on some of our experiences doing this work. And I think we focus on two main contributions. On the one hand, we have this theoretical framework that we have discovered interestingly on Twitter, when Arvind Narayanan made a comment about, hey, there's what happens right now in a lot of companies and a lot of public authorities is that the same kind of the same offices and the same departments that are purchasing chairs are purchasing very sophisticated technology. And that was based actually on a paper by Deirdre Mulligan and Kenneth Bamberger. And this paper has this idea of procurement as policy. So moving away from this idea of let's procure things because they're very simple and we're just buying them, to the idea of let's create a policy and let's create a process around how we're not only going to procure technology, but also implement it in an organization. So we try to build on that and we try to discuss that in the field of consumer protection, because there's a new regulation. It's already been there for a few years, but the Consumer Protection Cooperation Regulation in the European Union is shaping, as we speak, the future of digital enforcement in consumer law. And the second contribution is the fact that within this idea of digital enforcement, which we're using in a very broad sense, basically just making sure that the law that is in the books is implemented in reality. In the light of these activities, we see a lot of market surveillance interest, so monitoring tools. And we're going to get back to the word tools in a second in the conversation. But the question is, how afraid should we be about market surveillance? And there's here the Shoshana Zuboff book I have next to me that has been very much this kind of scarecrow of, okay, surveillance capitalism, everyone is being watched online. And the thing is that in consumer protection, the idea of market surveillance has been there for a while, because it has been basically protecting us from, dying from various, faulty products that we could purchase, not only online, but also offline.
Yeah, that sounds great. You just mentioned Shoshana Zuboff, and of course, I'm always, I think what was very interesting to me was that, of course, she published this book, which is quite a big one and, something you have to get into. And then when the COVID crisis started, I remember she published an op-ed in Le Figaro, one of the French newspapers, saying that, well, it might be okay for the state to, monitor the behaviors of the citizens and all that. So it's very interesting to see that depending on your political background, you may end up with different, preferences when it comes to surveilling people. Something we will discuss, I'm sure. But before that, Jerry, anything you want to add?
If I would add something, but maybe summarize what Catalina said already, is that there is a brave new world when it comes to market surveillance and the powers that apparently, for example, consumer authority agencies have. And I think we also somehow try to address and explain how this should be possible and how it can happen, what are the possibilities, what are the pitfalls, and open the room for further discussion, because it's a position paper, so it's what we think. We're interested in what other people are thinking.
As you just say, and you actually mentioned that in the paper, this is a position paper. You have a strong, stance on the matter, and I think this is precisely why this is such a good one. But going back to what both of you actually said already, you begin the article explaining that academics heavily discuss two forms of people digital surveillance. There is one that we mentioned already, which is surveillance capitalism, and another one that is state surveillance. But as you also say in the paper, state surveillance of companies is not as discussed in the literature, for a reason that we could debate for a very long time. But in any case, you remedy this problem by exploring how or what has been done when it comes to consumer protection to increase the surveillance capacity of national consumer protection agencies using computational tools. Again, we will discuss the meaning of that word. So, but I think it's very interesting, especially for competition lawyers, because for most of us, I suspect we are not aware of consumer protection too well, except for maybe GDPR and a few other, flagship regulation. So could you please unpack this reform for us? Mainly tell us when it was implemented and what's in it.
Yeah, so maybe Jerry, I can take that, and then you can build on some of the thoughts on consumer protection legislation. So I think perhaps even to wind back a little bit, the entire idea of market surveillance needs to be understood within the context of European Union law that has been there for now over 2 decades, a little bit over 2 decades. So in the noughties, for instance, like in 2002, we had this product safety directive, and product safety entails that whatever product you're surrounded by in your home right now and that you have purchased within the European Union, or you are targeted as a European consumer to purchase, needs to have certain standards of safety. And that's if we go into the nitty-gritty details of this, you're going to have a lot of different types of provisions on toys, on electric goods, like things that will need to have a specific composition, specific type of material. Jerry is now also working, for instance, with a safety gate database of the European Commission. And that's a very good, for those also watching and listening, that's a very good example where you can really see these requirements absolutely implemented in practice. So we have this product liability, product safety type of concept at the back of our minds as a pillar of European Union law, because it has been one of the, let's say, incentives to promote free movement of goods. And from that perspective, the idea that, wherever you're buying goods in the European Union, you're going to be safe. You shouldn't worry that if you go to another country, you're going to have a lower safety standard. But then the question is, how are you going to implement that? So obviously, there needed to be some market surveillance developments that are relevant here. And market surveillance has been kind of mentioned in a bunch of different regulatory frameworks. So there's actually a few regulations from 2008 specifically on market surveillance, and they build on this idea of product safety. And then the idea is that they also position market surveillance in a very positive light, and say, okay, this is something that we need if we want to have a safe internal market. So now that is the product safety part. Then in complementing this, there's also a development that we see not only with consumer protection administrative law, whether at European or national level, but we see this also with media regulators. We see this with, I'm curious if we see this also with competition regulators nationally or at European level, but data protection regulators that are really coming up with a lot of new approaches and new powers to have data access, to do investigations, to try to understand, okay, how can we evaluate and how can we understand the systemic risks that a lot of platforms in this digital market are actually leading to. So within this context, we have this very important consumer protection regulation, consumer protection cooperation regulation. And this regulation basically has been renovating or has been reforming some of the powers of national consumer protection authorities. And if we look at some very specific aspects in this regulation, we have, for instance, in Article 2, we have the kind of categories of infringements that the regulation covers. And we have three categories: intra-union infringements, widespread infringements, and widespread infringements with a union dimension. So I'm not going to go through the definitions because then that would be a dramatic reading of the regulation, although maybe that could be for something for another podcast. But maybe interesting to remember about this regulation is the fact that there are two major steps, let's say, in the work of these national consumer protection authorities, namely the investigation step and the enforcement step. So during the investigation step, it's important to understand, what can you do to really have access to data, to understand, which website is doing fake reviews, which website is selling these types of products that are not in conformity with various provisions of the consumer acquis. Maybe which websites are not giving you the rights that you have as a consumer under European Union law, like under the Consumer Rights Directive, withdrawal rights, rights to remedies if products are defective or not in conformity, etc., etc. And then after that, so after you kind of establish that there's an infringement, when you establish there's an infringement, then you have, as an authority at national level, certain powers, certain enforcement powers. And we had that before. So interim powers, you can go and ask for an injunction. Basically, the company should stop the action that is harmful, that is in violation with European law. But now, lo and behold, there are some new provisions in this CPC framework. And for instance, one of them is about mystery shopping. And mystery shopping entails just kind of acting as a detective and assuming a fake identity so that you go and you purchase a product kind of impersonating a consumer. So that has a very clear legal framework because in the past it didn't used to have that. And second of all, and that's in Article 9.4G for those who really would like to Google this, there are certain powers that are going to be there if there are no other effective means, and that even entail basically restricting access to an online interface or deleting a domain name before domain registries. So I think that those are really huge powers that perhaps the market doesn't really know that much about right now. There's a very big question as to how they're going to be applied. But we saw that in France already. Wish.com, I think, was subjected to the exercise of these powers. And then basically Google could not list them anymore because they were providing products that were not safe. So yeah, from this perspective, this is the new framework. We have to see exactly how these new discretionary powers are going to be applied in practice.
Yeah, so indeed, I mean, that's a whole new world. To answer your question, I'm not aware of anything similar when it comes to competition law anywhere in the world, but I'm sure it's coming. What we see now is that agencies are hiring as we speak, and in a few weeks we will be publishing contributions sent by those competition agencies to us. Everything will be open access. You will see that a lot is happening, but I suspect that first they need to hire, try to implement solutions or tools or projects, and then see that indeed you need the power actually to be able to gather the data and monitor and find new ways to sanction the companies. So I'm sure it's coming. But before I move on to another part of your paper, Jerry, I'm sure you have reactions towards what Katina just said.
Yeah, so I still remember when we're discussing with Catalina the CPC, and she was trying to explain it to me because I'm a computer scientist, right? So I'm still a bit slow when it comes to understanding how law works. I think it was a bit shocking, right, to realize that exactly what are the powers that for enforcement, right? Like to restrict access, to limit domains. And I think practically speaking, because I see things from a very practical perspective, one reason that happened, and here I can mention the safety gate example Catalina mentioned, is that in a way that feels maybe the only way to do it, right? To how to monitor and enforce. Like safety gate is this nice database that the European Union maintains. But then the discussion we had there in the project is that when things make it in the safety gate that this is an unsafe product reported by that country, it is already too late, because it means that there was already this reporting of this product. It was already confirmed by the authorities. It was, I don't know, the process followed and then it made the website. So it is already too late. So I think the reason for the whole, this power toolbox is because it's the only way for markets, for market enforcement, let's say, and the monitoring to have access to what is out there. And out there is literally the whole web, right? With the marketplaces evolving from web shops to websites, and then also mobile marketing. So I think the whole this power comes from the fact that they need to have access, which comes with responsibility, of course, into what is happening.
Yeah, and so in a way, that's the worrying part, right? Because if that's indeed the only way, and I think we can agree on that, then it's very easy to see how you can make a point that because it's necessary, we need to go ahead and move fast and potentially disregard some of the important issues that you are discussing in your article. So I think the rationale behind the adoption of all those new techniques and tools is very important. And that leads me to, maybe I will ask you the question to you first, Jerry, to ask you about what you've done in the past, because at some point in the article, you make the point that you need, amongst other things, to translate legal rules into computer science tasks. And I know that you two have been doing precisely that in the last couple of years. So could you please give us one or two concrete examples of what you've accomplished and the issues that you encountered along the way?
Yeah, so that's an interesting point that you raise, and indeed we have been working on different projects, exactly trying to take something from the law, create like legal taxonomies, and transform that into something that could be a computational task, which can be addressed by means of computer science. I think there we have been working on kind of different projects. Maybe we can mention our latest project, which involved studying data markets on dark web. It's still maybe not for common people, right? But it's still like a specific application where we had to take specific legal frameworks, apply them on some market that is completely unregulated, and then see how this can be transformed to something which can be addressed computationally. Additionally, we are also doing work on dark patterns, like many other researchers as well. And also from that perspective, we are interested in exactly taking UCPD, should be the regulation, and exactly try to understand, okay, what is a violation according to the HPD, and then how that can be measured, right? Because exactly, sometimes I find that law is vague, and they told me that that's on purpose, but then, we have this gap on, okay, for a computational task to be specific, it needs to be measurable. I don't know if Catalina has more examples, because we've been working on
But
this.
that I believe, or at least one of your publication is already out there. So for everyone interested, there is already, if they follow you on Twitter, they can easily retrieve the link. But I'm indeed curious, maybe for you, Catalina. So what are the legal rules there? And I'm reminded also of the DSA that kind of says that potentially, subliminal techniques will be prohibited. Well, it seems to me that advertisement is subliminal almost by default, right? It's a way to unconsciously try to convince people. So what are the legal rules here when it comes to dark patterns, and what did you do out of that to indeed create something that you can compute?
Yeah, so to build on the dark patterns example, that's a project that is ongoing. We have a PhD researcher who's working on that, Constanza Roșca, and what she's doing right now is she's actually looking at the Unfair Commercial Practices Directive, and it's always just so wonderful to hear Jerry speak about that, because I feel like, oh my God, this is a wonderful kind of two-way road, right? Where on the one hand, lawyers understand something more about technology, but then also computer scientists understand something more about the law. And basically, there has been a lot of interest that we see from regulators, various types of regulators around dark patterns. For those who follow the podcast and who do not know what dark patterns are, they're supposed to be these manipulative design, like interface design choices that are supposed to nudge consumers in unwanted ways, which, if you think about it from a moral perspective, or if you have computer-human interaction studies that show that people click more on this button if it's red than on this button if it's green, or vice versa. Now, the question is, from the law, what exactly is going to be a violation of the law? So how exactly do you set a threshold and say, well, if people click too much on this particular button, then they would enter a transaction that they would otherwise not have wanted to? That's Article 5 of the UCPD with a test of the average consumer. And that's really hard. And what we see in this type of work is that perhaps an initial step with very complex fields, very complex domains, for instance, like consumer protection and manipulative practices, would be to even identify, well, can we, out of the various taxonomies that are out there, like Colin Gray, Arunish Mathur, they have been working on these taxonomies. Out of these taxonomies, can we identify maybe dark patterns that are easier to measure, because they're also easier to define as legal violations, and therefore should become maybe a priority for detection if authorities have that capacity? So here, maybe some of the things that I wanted to reflect upon also about what we were discussing earlier. So market surveillance in principle can be a very good thing if there are certain safeguards, and if indeed authorities can apply legitimate surveillance frameworks also in a cohesive way that makes sense. And for that to make sense, we also need to clarify a little bit the law. So in the dark web paper that Jerry was mentioning, there we had a different type of legal framework with the Budapest Convention on Cybercrime, and there we wanted to see, can we define the various types of data offers that we found on, I believe it was 12, Jerry, right? 12 dark web marketplaces. Can we define them according to these definitions in an international convention on cybercrime? And basically, this type of multidisciplinary work can serve multiple functions. So on the one hand, it's very stimulating intellectually, but in the real world, it can very much perhaps be important for the setting of priorities, and also the setting of maybe kind of understanding what exactly technology can do, because there are also some things that technology can't do. And I'm very curious, for instance, about Jerry's opinion about, snake oil, and how, especially with the most recent machine learning revolutions and deep learning and whatnot, how it is possible to even understand what is snake oil and what isn't snake oil.
Yeah, I want to address that in just a minute. But before going back indeed to the dark pattern issue, especially if we do have PhD students based in Europe listening to us, it might be relevant to competition law. As you may know, it depends on the logic and how you try to apply Article 102, so abuses of dominance. To be very clear, let me just take 30 seconds here. The Bundeskartellamt, the German competition agency, says that you can actually abuse a market power, although a company in a non-dominant position on the market may be in a position to implement the exact same practice. So they sanctioned Facebook for gathering the data coming out of Facebook, Instagram, and WhatsApp. Although, of course, we could, here, the three of us today, create a startup and do the exact same. And according to the Bundeskartellamt, this is an abuse of a dominant position, because the link is between the abuse and the ability to impact the market at a big scale. So if you follow the same logic, you could say that a dominant company implementing a dark pattern will therefore infringe Article 102 of the TFEU. Some other people would say, well, no, because there is no link between the actual dominant position and the actual practice. So this is to be debated, but please do not disregard dark patterns as being something for just consumer protection, because it is also competition law related, and that's the beauty of it, right? We are actually trying to protect consumers from different angles, and it's interesting to see how it fits. But so going back to your question, and this is actually something I wanted to ask you, and here I quote you, make the point in the paper that the research that is necessary to break down regulatory questions into measurable tasks is in its infancy. And I'm curious here to hear from you, and maybe Jerry, you could get us started about what are the latest breakthrough in the space of computer science that you think could be helpful for lawyers listening to us, and also maybe what are the most significant advances that we are still waiting for, meaning the limitations as we speak.
So I think we mentioned tools, right? And I think Catalina is making fun of me because whenever we're discussing tools to do something, I always roll my eyes, right? Because exactly, I think this is kind of a wrong expectation from many people, either working as lawyers or simple citizens, that um, let's build a tool that practically will just monitor the whole World Wide Web and identify whatever we want. And of course, this is kind of not possible, and you really need to take it one step at a time. I think Catalina mentioned the dark patterns studies that have been done, and they are exploring these possibilities. But then the question is, how many of these exactly can we effectively measure and prove that they are indeed violations? So I think there the question is that we need to take it one step at a time and first see, okay, given the current monitoring possibilities, what does it mean to follow a marketplace online, collect some data, build a solid case upon it, and then use some of the algorithms to have a process that might lead you to something measurable, and that you can quantify that this might be like a possible violation. And we don't exactly see that, right? So that this is kind of a pipeline that involves many different steps, from designing exactly what do you want to detect, how you're going to do it, what data do you need, what algorithms do you need, what's the outcome, how do I validate that. Instead, we keep hearing people wanting tools to just make their life easier, which we understand, but practically this is not how things work, or how the whole realm of machine learning works.
Can I just hold you here just a minute, and then I give you back the floor? But this is also something that Catalina mentioned, the fact that to create taxonomy and to kind of make a divide between what's possible and when it comes to identify and what is not possible, or way harder because the law is indeed more elastic or soft, I think is very interesting, because what you see is that it may actually conduct the space in a certain direction, because of course you will go and start with the low hanging fruit, I suppose, and therefore it might mean that the policy of your administration will be actually oriented by the fact that it might be easier to identify certain practices. So of course, you will go there first, right? So we see that what's possible from a technical side actually impacts not only the policy, but also potentially the substance of the law and the kind of practices we are willing to tackle or to make illegal. I just wanted to make that point, because I think we often think about computational law and related, discussions as to how do we operationalize what exists already, but it actually goes, both ways. That being said, please, I go back to you. And again, I'm curious to hear from, the latest breakthrough, what you've seen in the space that's very exciting, where you thought, well, that could be used by lawyers or, in the legal space. And what are the things that you think we miss?
Yeah, that's a good question, right? Because I'm not sure I have a specific answer there on, what is there to be used, right? Because it's not exactly we're going to take something and, deploy it and unpack
Yeah.
it, right? But there is a whole suite of processes from machine learning that they are available to build upon, right? And of course, they all will rely on what kind of process you follow. As I said, how do you collect the initial data? Is it possible to collect this data? Because I think what you said makes sense, right? That maybe not everything is possible from a legal side, but also not everything is possible from a technical side. So if I think about, for example, the whole issue of personalization and then how that goes also into our mobile devices, I'm not even sure how you can start collecting data there, right? We tend to use our mobiles more to shop online, and of course that is something that stays on our mobile. We don't have the same data we have on let's say if you do a web shop where you can build different cases. I'm not sure if Catalina has more interesting breakthroughs that we could use there, but I think I am a bit more let's take what is there and try to build something, because I don't think it's really that straightforward to say, okay, let's do it now.
We're hearing a lot about Elon Musk taking over Twitter those days, and he's actually making the point that the algorithm or the API or the protocol, I don't know how which word is using, but should be made public. That would be interesting, right? Because potentially you could see indeed how they personalize the experience based on each user's, how what's the way they've been using to try and create this unique experience. But yes, going back to the point of the smartphone, of course, and especially with Apple in the mix, it's a totally different story. I just wanted to put that in the mix, but please, Catalina, the floor is yours.
Maybe even just to react to what you're saying about Elon Musk. So I kind of have this laid back attitude towards the Elon Musk example because of the paper that we wrote. So if you look at legal compliance, and also, so the idea, legal compliance is a term that makes sense, for instance, from the perspective of the companies, and then digital enforcement maybe is something that makes more sense from the perspective of authorities. So they are both about the same thing. How can you make sure that the rules that you have in the law are going to be also enacted and affected in practice in the digital sphere? And I think with Elon Musk, I mean, there's an entire narrative going around, like the future of Twitter and what Elon Musk is going to do or not do. But the truth of the matter is that with all of these digital monitoring trends that we see so clear, like clear as daylight in the European Union, we see this in daily practice. So again, not just by consumer protection authorities, we can see the CMA, the Competition and Markets Authority in the UK, has this amazing data unit that, and a behavioral hub as well. That's just an example. The Canadian Competition Bureau also has a data unit. So we see that a lot of public institutions are just, as you mentioned, like your metaphor, your famous metaphor, fighting fire with fire, right? So Elon Musk is not going to be able to reign above the limitations that all of these new enforcement frameworks are going to bring. And in the European Union, we also have the Digital Services Act in the pipeline. So I think in reality, it's just going to be something way more restrictive than the internet is making it sound like. But in the light of the metaphors I was mentioning, and I always quote you whenever I have the opportunity, because I think that this is actually a very good way of showcasing digital enforcement, so fighting fire with fire. I came up with my own metaphor because I think what digital enforcement can do, so theoretically, especially when a lot of activities are done online, it can make a lot of the invisible consumer violations that we had on the digital market visible. Right. So, and then that brings us to a question of scale. It brings us to a question of, well, what exactly should we focus on? You can scrape 7 marketplaces. What are you going to look at the prices? Are you going to look at fake reviews? Are you going to look at, I don't know, maybe even competition questions that might deal with prices, consumer questions that might deal with unfair commercial practices once more. So where do you even start? So I think that what you were mentioning, right, the idea that perhaps technology is going to shape various forms of, let's say, priorities, that is definitely correct, but that can also lead to an analysis of understanding what is more legally certain, and then starting it from there. And what is not legally certain, perhaps indeed there might be a need for procedures for first identifying how exactly the definitions can apply. And I think fake reviews would be a very good example. If you see the website of a fake reviews company that has what, like maybe a language model, they have some trained data, they take some, you know, fake reviews from Amazon Mechanical Turk, and then they say, oh, we can identify fake reviews on Amazon. How do you define fake reviews? Because that's going to be at the heart of your model. And if the definition is not going to have anything to do with the way in which an authority defines fake reviews, then what are you even detecting, so to speak? So that's why the interplay between legal frameworks and computational tasks is very
Essential.
important.
So to wrap up on the Twitter discussion, indeed, Twitter is not about to become 4chan. Sorry if it's a disappointment to some of you, but indeed, the law will still apply. Regarding the legal certainty aspect that you just discussed, I'm reminded of the work of a Codex fellow, Megan Ma, who is working on elasticity of contract. And so she's trying to come up with a way to indeed measure whether provisions in a contract are elastic, meaning that they can be interpreted in different ways or not, which of course is central when it then comes to transposing all that into computational task. And just to be clear, I think that none of us here are arguing that you should only do what can be computed, right? If certain legal provisions cannot be computed, it doesn't mean that they are not here for a good reason. It means that you need to be aware of the fact that it cannot be computed so that you can then weigh in on whether, you want to only or put your focus on what can be computed, how do you take into account what cannot be computed, etc., etc. But for those discussions to happen, you need to first indeed map what is easily computable and what is not. I just want to ask you two more questions. One regarding the lack of academic research when it comes to monitoring companies using digital tools or digital solutions. And you here make the point, and I think this is also something that I've heard, in private discussions with competition agencies, that if they use private tools, and we understand why, because indeed, if public solutions are not being developed, then agencies will have no choice but to use private solutions. This could have the effect of shaping their not only their capacity, but also the architecture of those public authorities. And I wonder here, what's the risk? And I know that some agencies, at least for the competition agencies, have been saying, including in our annual conference in public, that they were using such private tools. Some other agencies have been saying, not at all, we will never do so. We only use the ones that we develop ourselves. And I have no very, well-formed opinion as to what is the risk here of using the private solution. So is there any one of you who could highlight the issue for me?
Yeah, so I think in a way it's a trade-off, right? That you need to balance and then see what is it that you want to do, because of course let's say many of the algorithms we build, many of the frameworks, they might rely on building a model using, let's say, services from Amazon. And then how, for example, are you going to use the same framework that you develop from Amazon to investigate Amazon Marketplace, for example? And then the whole idea, also the point we make in the paper, is that where this will stop, right? In the sense that, of course, you can say that I don't have the resources, or I don't want to develop solutions in-house, right? But then I will have to find them in the private market, which is a fine argument if you balance this trade-off. But then the question is, for how long you can do it, right? Because then if you invest in a private solution, then of course you might be dependent on it, which might have different implications. But then let's say you want to do another follow-up, right? Or you want to build on that, then of course you're going to be dependent on that. And yeah, like for example, and that's not only for this problem we're discussing, right? It's general about IT investments, that how much you rely on external solutions and how much you rely on in-house expertise, which you can use and reuse for different projects and applications as well. And this is the point we try to make, that we need more investment and research in terms of people and what are the general frameworks we can develop, and then how this can be applied not only in one specific case, like to have this tool that I need, but in general for exactly building a whole set of these algorithms and processes.
Yeah, so more investment so that at least we have a choice, right? When it comes to the trade-off you are discussing, which is basically short-term versus long-term. Short-term, maybe you do have a private solution available, but on the long run, it might be not, ideal depending on what you want to do with those. What's the policy and the program and the ambitions you have. Indeed, it may be that we need to at least present agencies with two different types of solutions. So if I understand you well, you are not saying that consumer and antitrust agencies should not be using private solutions. It depends on where they put the needle in on the scale. But so if they do so, if they choose to go for private solutions, maybe for you, Catalina, which safeguards you think they should put in place to ensure that at least we ensure some sort of fairness when it comes to the use of those tools?
Yeah, so this is literally the $1 million question, right? So
Or more.
that would also need exactly at least $1 million of investment. But so that's why we were also saying that this type of technology is in its infancy, because also what a lot of scholars, including Deirdre Mulligan and Kenneth Bamberger, have been saying for a lot of years is the fact that especially when it comes to state institutions, there needs to be accountability, there needs to be transparency. So these are processes. So the safeguards that you're talking about, on the one hand, they need to be they need to have this idea of auditing, or they need to be based on the concept of auditing, so that we can see, okay, fake reviews, like what's your accuracy? How many false positives do you get? So how exactly do you know to contextualize and deploy that tool between brackets or between inverted commas, in such a way that you get the most out of it, in such a way that it's fair, transparent, and it's not going to be abusive. And for instance, a lot of security questions pop up, a lot of privacy questions pop up. And here we're also exploring this idea, and we had another position paper for CHI, for the Computer-Human Interaction Conference, also together with Gunesh Akar, who has been one of the authors on the initial dark pattern study from Princeton, and two junior researchers, including Constanța Roșca, the PhD researcher we were mentioning earlier. And there we were also trying to kind of brainstorm, okay, you have these technologies, how can they be detrimental to consumers? How can the consumers perhaps become harmed by the state wanting to go after companies, right? So do you have any kind of personal data that is going to be left in fake reviews or in normal reviews, and then consumer authorities end up processing that? And, what if that data is asked for by other authorities? What if administrative laws are going to permit the creation of multiple silos that can be brought together? And, how can that be abused? So these frameworks don't exist, and authorities need to develop them. There needs to be a thorough, ethics, privacy and security type of evaluation that is reflected in a serious process, also that an organization is ready to implement, because otherwise we run this catch-22 where, if you have an authority that just doesn't have the internal capacity and resources to develop technology, how on earth are they going to assess it? So that's where I think also scientific work can help.
So I think it's such a great research question indeed, the fact that, by going after companies, you may harm individuals. And I'm delighted to hear that Costanza is indeed conducting such research under your supervision. So what I hear here is that there are two aspects of what agencies may want to consider when adopting those, especially private solutions. First, how to protect or to be fair to the companies and indeed to the individuals they are trying to investigate. And another one will be also for their own sake, right? They may want to be in a position to explain what they've been doing, especially if their decision is being challenged and go before the courts, because then it would mean that they will need to argue why they have taken the decision, what is the basis for it, and all that. So it goes both ways. I want to ask you my final impossible question, but please answer the question and know that you are being recorded right now. The question is as follows: where do you think we'll be in 10 years from now regarding what will be possible to achieve in the field of antitrust, or I'll give you consumer protection, using computational tools and solutions? I don't know who wants to go first on this one, but maybe Jerry,
Yeah, I'm gonna be modest, right? But also gonna be maybe a bit positive in that sense that we see that there are more and more initiatives to protect consumers, and that's why I'm fascinated to work on this area with Catalina. So I would say that in 10 years from now, hopefully we should expect to have more technology integrated as options for consumer protection authorities in order to empower consumers, because in the end that's the end goal. Right now, to which degree we will have to materialize these things, we will have to see. But I think also based on the CPC regulation that Katarina mentioned and the powers that are there, that remains to be seen to how much we'll be able to achieve in a few years, and also where the balancing will be between investing in expertise, which is going to bring results back long term, and just to private solutions which might do 1 2 tasks here tomorrow, and then we drop it like 2 days later.
And so just to be clear, to be sure I understand, you mentioned the use of new solutions by agencies to protect consumers. Do you also see a future of developing tools directly available to consumers, right? So they can protect themselves against, digital infrastructure.
Yeah, I think this is as well possible, right? But I think for that also, I guess you also need to follow the whole process, right? And make sure that whatever you are releasing is going to be used in a good way, because it's a different thing to have it as an enforcement officer, let's say, and use it as advisory tool or whatever, and then act based on that. And different thing to give it to consumers and then they don't know how to use it, or they don't know how it works, right? So I think maybe that should be like one step, I would say, after we manage to have some basic, at least, options for at least initially consumer authorities.
All right. Yes. Thank you very much. This is what I always, think about as being what in my mind is George Orwell, 50%. Because in the book, he's making a strong point that the state can use tech to actually, punish and monitor the citizens, but he's not making the point that the citizens can also use the tech to fight back against the state, which I think is a bit of what blockchain is here to do. But anyway, it's another discussion for another day. Maybe Catalina, before we go, what is your what is your forecast here for the future?
The forecast that I have right now on the basis of the insights that Jerry and I have been developing is that we just need a we need a very big solution that does multiple things, right? So consumer empowerment is one thing. Trying to understand how to increase the technology capacities of consumer authorities is another thing. Trying to understand how universities can develop public interest technology, because they are repositories of trust in society. How can they help navigate that? That's another thing. So I think we just need to do everything at the same time. And I think in the next 10 years, what we will probably most likely see is a normalization of digital monitoring. And again, done well, this is something that we shouldn't run away from because it's necessary. So there's no way that in the next 2 years, unless a cataclysmic event happens, there's no way we're going to become a technology-less society. So the only way ahead is to have more and more technology. So we need to now also make sure that we run with this technology from the perspective of law, from the perspective of regulation, and also from the perspective of enforcement, and curtail it where the case might be to do so. So normalization, I think, is going to be one thing, of course, done right. So read the paper if you want to see, for instance, some incipient thoughts on how that could possibly be done right. But then maybe another thing that we will also see is the fact that hopefully the legal complexity is going to be tackled. So the complexity of the law, where we see right now, on a marketplace, you have data protection and competition rules and consumer protection and media rules on some platforms and a bunch of other legal frameworks, and how they come together right now is just a very, very messy process. So hopefully in the next 10 years, what at least I hope to see is a little bit more clarification as to how this legal framework applies, and a little bit more coherence within the framework.
Well, you just mentioned the word complexity, which has been an interest of mine for quite some time. One of our forthcoming articles will be actually discussing complexity and computational solutions in the context of antitrust. The beauty of it is that indeed you have all those regulations coexisting, and according to complexity science, their coexistence actually influence the others. And you actually see that in the Data Act, they refer to the DMA, the Digital Markets Act, and in the AI Act to the DSA. So all that is creating an ecosystem that is really hard to navigate and to compute. So that's the beauty of it. That's why we're here. I was delighted to have this discussion with you. I recall everyone that your article is already available on our website in open source. It's computationalantitrust.com. I wish you a very good day. I'll see you very soon. And take care. And if you can, someone else too. Cheers.
Thanks so much for the invitation, and looking forward to the next papers in the series.
Yeah, thanks a lot for the discussion, and see you around.
Bye-bye.